So I'm going to give you my example, and this is by far my favorite example of the old category approach. And it's the dying declaration exception to the hearsay rule. Okay, so we have the rule, hearsay evidence is inadmissible. And then we had an old common law exception developed 200 or 300 years ago called the dying declaration exception to the hearsay rule. And it had very strict criteria. The criteria that I like the most is this one. The person, or the declarant, who's now dead, had to have what we called a settled, hopeless expectation of death. In other words, they knew they were going to die. Now, I'll tell you how bizarre this exception is. What it meant was that the victim would be maybe at the scene or maybe in a hospital, and a police officer, in order to take advantage of this dying declaration, would go up to the person and say, "You know you're going to die. Now, tell us who did this to you." Now, imagine the compassion that that shows for the victim. But that was the requirement. The person had to believe that they were going to die. The rationale was a simple one. If you're about to die, you're going to tell the truth. No one wants to meet their maker with the last thing they did was to lie. That's the theory. So that was the exception. And then, of course, there had to be an exception to the exception. And the exception was the person had to die. And it could only be used at the trial of that person either for murder or manslaughter. So if the person happened to live, even if they were in a vegetative state, couldn't talk or anything, it wasn't admissible because they weren't dead. That's why I like it. It's such an interesting exception. It says so much about where our rules of evidence came from. Well, there are a few problems with the dying declaration exception to the hearsay rule in the modern world. First of all, this idea that people think if they're dying that they're about to meet their maker and therefore only tell the truth only works in a system where people actually believe in God. Well, you can't. 200 years ago, you could make that assumption. And you could make that assumption in a country which was essentially homogeneous, where they were all Christian, all Catholic, Protestant, whatever. Well, you can't necessarily make that assumption anymore. The second one, it's an obvious one, is most people don't think they're going to die. Because of modern medical care, even people who are very seriously injured still hope they're going to live. So even if the police officer goes up to them and says, "You're about to die, now tell us who did it," they still think, "Oh no, I'm going to live, I'll get proper care, I'll live." So the exception didn't make any sense. Thirdly, the exception applied even in circumstances where it was very unclear whether the victim was able to accurately identify their attacker. They may have been stabbed from behind. So they may have thought, "Oh, well, my husband must have been the one that killed me." But they may not have known, and yet it was still admissible. And then finally, if this evidence is so reliable, if the rationale behind it is so, the rationale works, why just murder and manslaughter? Why not some other charge where the evidence would be necessary? So today, if you were to look at the dying declaration exception to the hearsay rule, you'd have some serious concerns about it. How would it work today under the principled approach? First of all, you look at necessity. You'd say, okay, do we need this evidence? Well, yes, we need the evidence because the declarant is dead or unavailable for some other reason, perhaps in a vegetative state or unable to communicate. And then you would try and understand whether or not the statement was reliable. What were the circumstances under which it was made that would assure you that this evidence is worth receiving, even though the defendant in a criminal case would not have the opportunity to cross-examine the declarant? Did the declarant have a motive to lie? Is there Are there reasons to suspect that they would not be telling the truth? Were they able to observe their attacker? Was there anything that would interfere with their ability to remember the events? Are there any problems with the way they communicated? Were we properly understanding what they said? So the modern approach would not be this category of dying declaration, but rather a principled look at the circumstances under which the statement was made. So if you were to look at our rules of evidence today, what you would see is that the Supreme Court of Canada, particularly over the last 20, 25 years, has gradually tried to apply a principled approach to each of the areas. And of course, in our system, which is highly dependent upon precedent, Supreme Court of Canada makes a decision about what certain kinds of evidence should be admissible. That rule is binding on all the other courts. They've looked at hearsay. As I said, they've looked at privilege, again, very much influenced by what Dean Wigmore had written about why we have privileges, why we exclude certain otherwise very reliable evidence. Solicitor-client privilege is the one that I think most of you are familiar with. We have taken a very hard look at expert